This is a team briefing. It's an internal recording which we use for our own team's education at the law offices of Rajiv S. Khanna PC, immigration.com. The reason we are putting this out into the public is because some of the things we are discussing, people have been asking us again and again, and it might be useful to get some basic understanding, perhaps of the new national interest waiver standards and the accompanying issues. Okay. Let me begin with reminding you folks. I know some of you from our team are here, not everybody's here, but since we'll have a recording, the rest of the people involved with national interest waiver process can learn about it later. And of course, we do these things on a regular basis, so we can talk about it again. But going back to, I want to remind you all that national interest waiver used to be, I always used to tell people that national interest waiver is, the decision making is so erratic, it's like expecting some sort of consistency from a drunken monkey. That's how poorly decided these cases were. Since the New York Department of Transportation case a couple of decades ago, that was the situation. Really, really bad set of decision making standards, very difficult to do any kind of prognostication, future, whether we are going to win a case or not. We won a few cases. We also discouraged a lot of cases. We don't want to waste people's money. Now I think we can be a little bit more aggressive with our national interest waiver cases. What has changed? Let me get right into it. If you go to our website and go to my blogs, the very first entry in the blogs now is about the new standards for national interest waiver cases. We have it posted also on our Facebook page as well as on our LinkedIn page, but you guys should also always refer to my own blog entries. So the three standards that we are going to look at now for national interest waiver are: number one, the proposed work will have substantial merit and national importance. Substantial merit, national importance. And how has that changed? The previous standard was substantial intrinsic merit. So their previous formulation of this principle had the word intrinsic. What does that mean? That means inherently, when you look at the work and you go, oh, this work must be very beneficial to the USA. Government has now said that, or Administrative Appeals Office has now said that the word intrinsic doesn't really add much to the analysis and can actually be misleading. And Administrative Appeals Office pointed out in the case that I have mentioned, I think I've sent it to everybody, the Nasser case, where Administrative Appeals Office pointed out that within that New York Department of Transportation case, the old case, we've got 4 different formulations of what our standards are, and they are all very confusing. Okay, so going back to the new standard, which says the proposed work will have substantial merit and national importance. We're not going to look at some sort of good as gold, internally an inherently shiny standard. We don't look at what is intrinsic. Prove to us how your work will have substantial merit and national importance. So I've been answering questions, even in our frequently asked questions, somebody asked me, so if I start a new company here, can I get a national interest waiver? And the answer is probably not, because what is the substantial merit in your work? Let me give you another example. Remember, we did an H1 for this gentleman, Anna will remember. Anna, we did an H1 for this gentleman, or maybe Diane was involved in that also, in which he got out of school with a PhD and started his own company, which they have huge plans for, and their work is going to involve Internet of Things. So he basically started his own company and did his H1 through his own company, and already he's got secured the first round of funding, and we helped them in all that. Somebody like that could probably go for national interest waiver, because the work is at such a huge scale. What is Internet of Things? Where everything talks to everything else. So you could, I mean, it's already becoming a part of, like in my own home, I've got Google Home. It can talk to my refrigerator if it's internet sensitive, internet alive, or Bluetooth alive. Your lights, your garage doors, all those things can talk with everything else. So you can have control over the internet of all these things, all the devices at home. That sort of work, which has far-reaching implications, could be very well a subject of national interest waiver. But if you're opening a company to just do some basic trade work or some basic development, software development, you probably won't be able to get a national interest waiver. But it's too early. I hope I'm wrong, and I hope that government changes its mind eventually. But right now, it appears to me that ordinary entrepreneurship would not meet the test of substantial merit and national importance. In the graphic that I drew over the vacations while you guys were having a good time, I was working away. I hope you folks are embarrassed about that. But what I have actually everything pointed out there. If you look at nothing as just the graphic, both for this and for the new I-140 regulations, if you just look at the graphic, it tells you everything you need to know. So here they said the first prong, substantial merit and national importance, focuses on the specific endeavor that the applicant is going to undertake. It can be demonstrated in a range of areas. So you can be involved in arts, business, entrepreneurialism, science, technology, culture, health, education, almost any field. Almost any field of work could qualify potentially. But you've got to focus on the work and show that it has the potential to create significant economic impact. So big companies could come, it doesn't have to work out like that. They go on and say that we are not going to hold you to your ideals and to your business plans, but at least show us something concrete that demonstrates to us that there will be a huge economic impact factor. Then they go on to say that even sometimes if not impact on money, or the money is not the bottom line, if your work is going to be research and you're going to advance human knowledge, for example, in pure science, if you're doing some kind of a new genetic technique which is by itself not commercially good, but it advances human knowledge, we are going to consider that as work which has merit and national importance. So any work that you do which tends to, for example, create an edge in technology. And one very important part here is, remember that even arts. So if I had an artist, like we did a few cases from India of people who were music performers from Indian classical music system, or they were singers from the Indian classical system, or dancers, they might be able to qualify for national interest waiver because they are adding to the cultural diversity of the United States. USCIS actually made a few decisions favorably, and then they stopped doing them. I think this decision opens the door for something like that. I'm cautiously excited that this decision will open doors for a lot many more people who were barred out for very difficult to understand standards earlier. Is everybody okay so far, guys? Any questions for me?
No.
Okay, all right. I'm assuming that everybody here has understood what I said so far. One important thing was, if you remember, we had a case in which somebody, and I don't know, Diane, you would remember, it's a very old case, but it comes to mind.
What are you implying?
Well, you are young, but the case is old. By the way, Diane was telling me that her 20th anniversary with our firm is coming up. So I did suggest that we should all get together at Diane's house for dinner. That would be celebration, right? Okay, going back to, you guys distract me. Going back to work, there was a big problem with geographical impact. So for example, I was an environmental engineer and I was working in, let's say, Ohio. And government said, well, your work is local. You're doing some very good work. For example, I was, this is actually the case of, this is one of the cases we won. And Suman, you'll remember this because this was one of my friends from Punjab University. His case we won because the work that he was doing was actually being implemented nationally. He was, if I remember correctly, he was pumping gas back into ground, some of these emissions, and they were being absorbed back into ground, something like that, some deep well technology. And he, of course, we won his national interest waiver. But another case, very similar to his, was denied because it was not being implemented nationally. Under the new standards, a case like that, even though it doesn't have geographical impact nationally, it could have national importance anyway. And they have made it clear that this overemphasis on the geographical breadth of endeavor is not necessary. Okay? So the standard of substantial merit and national importance is softer than the standard that we had before. The next is a very important development, which is applicant is well positioned to advance the proposed endeavor. So the old standard was that they didn't really actually articulate it like that, but they used to say, well, how are you, and we used to get RFEs like that all the time, how are you helping US national interest above and beyond another ordinary professional? So let's say you've got a PhD and you're working on the Internet of Things. Well, there are 10,000 other people doing the same thing. How is your work more exceptional? Government said we're not going to ask that anymore. They said that in 2-3 different places in the Dhanasa decision, in various contexts. They're not going to make me compare my work to everybody else's work. They're just going to say, what does your work do for USA? Where is the merit? Where is the national importance? And substantial merit. And also remember, our burden of proof is preponderance of the evidence. What does that mean? More likely than not. Even though there is some doubt what I'm saying is not acceptable to you, if it is more likely than not likely, you must approve my case. I only have to prove my case by 51% evidence, not by 99%. Okay. So by calling it well positioned, what they're saying is that your education, skills, knowledge, record of success in related or similar efforts, a model, a plan for future activities like a business plan, any progress you already made towards the endeavor, the interest of potential customers, users, investors, or other relevant entities or individuals, and economic impact. If you are actually already doing it or about to do it, and it's quite clear from your resume that you can do it, we will accept that. You are well positioned to advance this endeavor. So it's not, it again doesn't require proof beyond reasonable doubt. It only requires preponderance of the evidence. I know some of that we are talking about is quite vague, but that's where we come in. We can actually use this as guidelines and make cases out of it. So when I see a case, like Diane, you are right now working on a case for that SAP expert, right?
Right.
I think his case could go under national interest waiver too. So that's another discussion. Any active cases that you have where we have more than one option, at some point I want to discuss it. The other client, the EB1A client that we were working with, we already told him about the NIW standards. So, just keep that in mind that sometimes, in fact, often we'll have more than one option. NIW will also be an option. And I'll come to why I don't like NIW for people born in India, China, Mexico, Philippines. Other countries is great because their priority dates are not backed up. This is still EB2. And remember, someone was asking me a question about somebody. One of our clients asked her, we've already got EB2 approval under PERM. Should I do NIW? And I said, bring it up, someone, while we are talking about this in the team briefing, and you can bring it up at that point of time. I don't think it helps. The only thing NIW is going to give you is ability to change employers, but there are so many changes in the I-140 regulations that might not be necessary any longer. So NIW, if I did for him, only thing I'll get him is a little bit mobility. Other than that, he's not going to get any advantage. He's still EB2, right? Everybody clear on that?
Right. Yeah.
Okay. So Again, if going back to the well positioned to advance the endeavor, they said we are going to look at your resume, we are going to look at your plans. So we are going to look at your past, present, and future and see how you can help this work that you're planning to do. Okay? Another thing I kind of got from the decision was that AAO was saying this, and I highlighted that in our graphic. The possibility of future success will not be made too difficult to prove. So in other words, we're not going to say you have to show us beyond all reasonable doubt that your business plan is going to be successful. We can't hold you to that impossible standard, which I thought was also another good thing. And the last thing which they say is the balance favors grant of NIW. What does that mean? So the idea is Congress created a scheme to protect US workforce. What is that scheme called? That's called PERM, labor certification. On the other hand, Congress also created a scheme to skip that process of labor certification. That scheme is called national interest waiver. So USCIS has to balance each case to decide whether in this case it is a good idea to skip the national interest, to skip the labor certification. And they had some interesting examples there. We have had cases fail because government said, well, why can't you do we filed a national interest waiver, government came back and said, okay, well, fine, your case looks good, but tell us this, why should you not file a regular PERM-based application? Sometimes it is not possible to, for example, for the gentleman to get or the lady to get an employer. They are doing their own work. And NIW allows you to file your own application and do your own work. But labor certification, PERM, you need an employer. That's one example. Second example is in the Dhanasar case itself, where somebody has 3 degrees or 4 degrees, and really those kind of qualifications are difficult to quantify as we normally would in a labor certification. And those of you on the phone who are working on non-PERM based applications like national interest waivers and EB-1As won't know what I'm talking about, but someone can explain that to you. That in labor certifications, we have to quantify each and every thing. 5 years of experience in this and this. But it is not possible always to quantify certain things. These are intangibles. So it is going to become, in my view, overall, a lot easier to prove that the balance favors not asking for a labor certification. And each case, of course, will be different, but we will be able to make a case much easier than we were before. So once again, we are going to look at the new standards, substantial merit and national importance of the work, applicant can get the job done, and the balance favors grant of national interest waiver. Those are the new standards. I finished with my recording. Just, by the way, on our blog, we keep answering these frequently asked questions that people are posting. So we are developing a better knowledge base. If you scroll to the very bottom, I've answered a few questions like Aditi asked me, in the pending cases, are they going to use the old standards or the new standards? She's got a NIW pending. And I said, in my view, they should be using the new standards for the pending cases. But if they do use an old standard, you can always refile the case. There's no law on how many times you can file an NIW. You can file an NIW 10,000 times, and you can file it along with other applications, EB-1A, EB-1B, or a PERM-based EB-2 or EB-3. All of this is possible. Then another person asked me, can a person with H4EAD, a bachelor's degree in computer engineering, master's degree in MBA, start a business and do self-filing? And I would have said yes, but if it's just an ordinary entrepreneurial effort, maybe not. But if you had a grand scheme, I think that would work out. So remember that idea of merit, of some sort of specialness about your plan. I think it's too early to say that definitively, but that's an example, and people are asking us these questions. Then somebody asked me, can bachelor's degree with extensive work experience get the EB2 possibility? And I said, well, you can't. I want to point something else out to you. There's something weird about the regulations which had been largely ignored, but it might become relevant at some point. So keep this in mind. I will point that out to you. Give me 1 second. So national interest waiver is available to people who have advanced degrees or exceptional ability. What is advanced degree? Degree above bachelor's. So, for example, a bachelor's degree in law requires a bachelor's degree before that. So, even though it's a bachelor's or a first degree in profession, it's considered to be advanced degree. Are you with me so far, everyone?
Yes.
Advanced degree is a degree above the bachelor's level. I do need to hear from everybody a yes.
Yes. Yes.
Okay.
Yes.
Okay. Because I'm confused whether I'm going too fast. Sometimes I don't know if I'm making sense to everyone. But I'm hoping that, if there's a problem, just stop me. Now, the question is, what requires advanced degree and what requires exceptional ability? What if I don't have advanced degree but I have exceptional ability? It's a very interesting issue. When I looked at the regulations and I analyzed the regulations, what I find is, and I could be wrong about this, but this is my interpretation. You can do a national interest waiver in science, arts, business, or professions. The first three require exceptional ability, but professions requires advanced degree. Once again, science, arts, business requires exceptional ability. Science, arts, business. Professions requires advanced degree. So, if you are proving your case under science, arts, or business, you will only need exceptional ability. If you are proving your case under professions, you will need advanced degree. Very interesting approach, but it can make a big difference on how we plan the case. Remember, let's take an example of I'm trying to think of somebody who's both, let's take the example of arts. Let's say somebody is a opera singer. Okay, they can go under arts as well as under professions because their profession is a performing musician. And if we go under professions, we'll need to prove that they have an advanced degree. But if we make their case under arts, we need to prove exceptional ability. And exceptional ability has been defined differently than under EB1A or EB1B that we used to have an earlier definition for. Now they are saying exceptional ability is ability beyond what is ordinarily encountered. I'm speaking from memory. I think that's the formulation. Beyond what is ordinarily encountered. So it is not like EB1A where we have to prove you are one of the very few people who have reached the pinnacle of your profession, top 5% or top 3%. Here, exceptional ability simply means above that which is ordinarily encountered. So depending upon the way we make the case, we can make the case under professions for advanced degree people or exceptional ability for people who don't have advanced degrees. That's the way I read the regulations. And if you guys look at the cases and look at the regulations and think that I'm mistaken, let's argue about it, let's talk about it. Is this point clear or no?
Yeah, how would you define ordinarily encountered? That's...
Well, Diane, it's the same thing. It's the same problem that we have under EB1A. How do we define?
Right.
We would use the same principles. I would still use the same principles from EB1A, EB1B. But the idea is my degree of proof would be probably lesser.
Okay.
So use the same guidelines.
And
Use the same guidelines.
does that require
Publications,
and
original
require
research.
some type of documentary evidence to
Yes.
show this?
Yes, of course.
Yeah.
Of course. So you'll be making both an EB1A or EB1B case as well as an NIW case. It'll be twice the work in some instances. But that's the idea. The idea is we'll be doing both things.
Okay.
Okay? Everybody all clear on this, guys?
Yeah.
Okay, then I'll call it a stop. I'll stop the recording. I'll send you guys the recording or a link to the recording, and we'll make it public as well so people can have better idea of what is involved here. Okay? Thank you, everyone.
Okay.
Bye. every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.